It all starts with a claim of innocence from somebody who's in prison. It's really as simple as that. Somebody's in prison that wants to make the argument that I'm innocent, and that sets into motion a cascading series of events and steps along the way that leads, in some instances, to the courts relooking at the original conviction.
In some ways, it's not that different than any other post-conviction writ action. The original trial, of course, assuming there is a trial, some cases are resolved by pleas. Most cases are resolved by pleas. Many times innocent people plead guilty because they don't want to pay the trial penalty. But, in a post-conviction writ of habeas corpus involving DNA or otherwise, of course, number one, there is no jury. Number two, you might not even get a hearing. You've got to convince the trial court. The cases go back to the original trial court, and you file a writ, kind of like you'd file a lawsuit in a civil case. You file a writ making certain allegations, and then the state may or may not respond. They don't have to, and the judge decides whether or not there are any real relevant contested issues of fact. The judge may say, well, there's no contested issues of fact here. Even if everything you say is true, you lose, or whatever. And if there are, he or she decides how they're to be resolved. Are they to be resolved by affidavit? Are they to be resolved by live testimony, subject to cross-examination, or how? And so you have your hearing, or not, and the judge makes a ruling.
I think what a lot of people don't realize is that the vast majority of the claims are dismissed because anybody in prison wants to get out of prison. But in a very, very small number of cases, as a percentage of all convictions that have happened over the last 30 or 40 years, you will have an individual who is in prison that did not commit the crime for which they were convicted. And so when that happens, you will have individuals who will advocate for that individual to convince the courts to relook at the case. And what's interesting about that is that can very much be a political endeavor. There's a case that has to be made. And so there's a lot of effort that goes into trying to showcase the innocence of this individual to get people's attention. And that can involve use of the press. It can involve social media. It's essentially a campaign.
Say it's what we call a freestanding claim of actual innocence involving DNA. And what you're saying is, well, he or she may have had a completely fair trial. We can't say, all the appeals have been lost. The courts have determined there were no constitutional violations. But the jury just reached the wrong result. They just convicted, and the DNA that wasn't available back then and is available now proves that. And you've got to prove it by clear and convincing evidence. It's not quite as high as beyond a reasonable doubt, but it's much higher than by a preponderance of the evidence. So you've got a very heavy burden of proof. The Court of Criminal Appeals in Texas calls it a Herculean burden. I guess you have to be Hercules to carry that burden. And so if through the DNA testing in a DNA case you prove that the person convicted just didn't do it, somebody else did, and maybe you're even able to prove who else did, notwithstanding that they got a completely fair and constitutional trial, the wrong result was reached, and we've proved that by clear and convincing evidence. Please find them actually innocent. And then in Texas, the procedure is the judge makes a ruling, makes findings of fact, conclusions of law that are only a recommendation, and then they go up to the Court of Criminal Appeals, the highest court in Texas for criminal cases, and 9 judges decide whether they agree or disagree with the court below. It could easily take 8 to 10 years if everything pretty much went right.
After about 1989, late 80s, early 90s, and forensic DNA started to mature and establish itself, now all of a sudden we had the benefit of an incredibly powerful piece of evidence that we didn't have before to provide an additional check and balance to the system.
Think about the way that evidence was handled a generation ago. How fair is it for you to critique all of that, given how we do things today? So there's a part of that it seems like it's a very easy argument to make, but in a real sense, not understanding that evidence doesn't exist because it wasn't seized properly and it wasn't maintained properly. That disadvantages the person trying to demonstrate that they did not commit the crime that they've been charged with. So you have to bring that to the attention of the jury. And that creates an interesting situation for folks like me. I've had to develop opinions about the sufficiency of an investigation from 20 years ago, 30 years ago, because it is something that a jury needs to consider or a judge needs to consider as part of their post-conviction, discussion. And, interestingly, how we do our job has not changed a great deal. Sort of the sequence of the tasks of the scene, even how evidence moves from one place to another hasn't really changed. Obviously, the technology, the instrumentation at our disposal has changed dramatically. Particularly with older cases, what you see is that evidence is actually consumed in testing. And so an item of evidence where today I could get enough DNA by simply swabbing a surface, you would find evidence from even 10, 15 years ago where there were holes cut in that evidence or there was real damage to the evidence because, the samples that we needed to obtain were much larger. And so if the original evidence or if the evidence was originally tested in a place where we got a mixture where perhaps we weren't expecting it, or it was, a protocol was used that is not something that we would use today, there'd be some discussion about whether or not we want to approach this item in a different way.
And so you decide what it is you're going to test and who is going to test it, what lab is going to test it, and what methods and tests they're going to use on it that would yield probative results. And then you get the results back and you argue about what it means.
Also, as part of that, the lack of understanding of the investigators means that sometimes we don't ask for the right testing. And I think that there is a reflexive request for what we perceive to be the most sensitive testing. But perhaps the most sensitive testing is not the most probative testing. And before we reflexively say, let's get DNA, perhaps what we need to do is understand whether or not that DNA comes from a biological fluid, because that biological fluid gives that DNA much needed context.
On what planet would we not want to know the answer? If this was a wrongful conviction, why would we not want to test that evidence? But that's not how things are in law. They don't want to talk about error. They don't want to acknowledge error. And I think forensic DNA analysts feel that on a day-to-day basis. I feel in my work when I have to confront an analyst with a misstatement or an error that there are varying ways that information is received. As experts, we're supposed to be open to constructive criticism. We're trained on that as scientists, but the lawyers are completely different. They want as clean of a record as they can possibly have and as bulletproof of a case as they can possibly have. And they don't like the introduction of uncertainty or error when we're talking about their evidence.
There shouldn't be this resistance to post-conviction testing simply because it's a case that has already been adjudicated, right? So the finality of the jury verdict does not really mean that the case is over anymore. But I think, if we are being more objective in the idea, in the sense of what does it mean to look at evidence, we might hyper-focus on the idea that if a particular scenario is true, therefore DNA must exist on a particular item of evidence. And so, what might happen? You might sample an item of evidence that you understand to have probative value, and you don't find the DNA that you anticipated. Does that mean that that item doesn't have probative value? Or does it mean that the wrong area was sampled? Or does it mean that the item was stored in such a way that the DNA that did exist at a previous point in time is no longer on the object in a sufficient quantity that it can be amplified, and and you can determine who the contributors are to that mixture.
And I'm seeing the differences in funding for investigators, for criminal defendants, for public defenders versus the prosecutors. The prosecutor's office here in Broward County, they have their own investigators, they're well funded, and if they want to investigate someone deeply, they are going to be able to do that. They have the funds to do that, whereas I don't feel like the defense community has that same level of funding. So there's disparity.
Steven Brody is a senior. He's a deaf kid. He's been deaf since he's 18 months old. He's adopted, but he goes to Richardson High School. And one of these attacks or one of these crimes takes place in Richardson in August, I believe it was 91. And this little girl is abducted. Her parents are asleep in the next room. The perpetrator enters through a window and sexually assaults her in some form or fashion, and then returns her, and she can't identify anybody. There was a blanket put over her head or something, so she didn't see anything. So this case goes unsolved. And then in the summer, I guess after he graduates, I guess it's been the summer of 92, he does get caught burglarizing a coin-operated machine at a public swimming pool. And they take him in and they question him for a few minutes on the coin-operated machine burglary, which he quickly confesses to, tells them where the crowbar is or whatever. And of course, he's deaf, so and the detective doesn't, so there's difficulty communicating. But they real quickly, and for the next, 72 hours, interrogate him about this home invasion, sexual assault of the little girl. And after that long, they have what they call a confession, and it's the most bogus thing you've ever seen, a lot of it they have to communicate in writing and notes back and forth, and you can see where the detective's leading him on, and he goes, "Okay, so what time were you in that neighborhood?" And Steven's saying, "Well, I think it was 3 o'clock in the afternoon." He goes, "No, this happened at 5 o'clock or 4 o'clock in the morning. You need to," and this is like in writing, you need to say it was at 4 o'clock in the morning. And so that's how bad this is. And so he gets a court-appointed attorney, and he ends up, the judge denies the motion to suppress the confession, because they always do. And so he's going to go to trial, and they offer him a deal for, I think it was 5 years to do, which, if you really did that, that's a pretty good deal, for a criminal but if you didn't do it, it's a terrible deal. But he takes it. And after he takes the deal, within a month or so, I think, after he takes the deal, they catch a guy, the Dallas PD, to their credit, catch a guy like at 3 o'clock in the morning. And there's DNA, there's not DNA in Steven Brody's case, but there's DNA in this other case, and this guy is connected to that crime through DNA, so he is good for it. But the Richardson crime scene officer gets curious and goes and gets the known fingerprint from this guy, the guy that was arrested after Steve, and compares it to what was lifted from the window screen, and it's a match. And so he goes to his boss, the chief, and tells him about that, and the boss says, "Well, don't tell anybody, whatever you do, don't tell anybody." And they finally said, "Well, let's get a second opinion. Maybe our buddies at the FBI will help us out and say it's not really a match." So they go to the FBI expert, and he says, "It's a match." And so we prosecuted him, 20 years later, once in Dallas County and once in Collin County. Even though it was City of Dallas, it was part of the City of Dallas that went into Collin County. So Dallas County convicted him, gave him life. Collin County convicted him, gave him life. And we exonerated Steven Brody.